A very good morning to everyone present here. It is my great pleasure to introduce our first speaker of the International Conclave on Media and Entertainment Law, Mr. Chris Eastham, to deliver the keynote address. Mr. Eastham is a partner in the technology and data team at Field Fisher's London office, but to simply state his title does little justice to the depth and breadth of his expertise. With over a decade of experience, Mr. Eastham has established himself as a formidable force in the realm of technology law. Recognized by chambers and partners as a global market leader in artificial intelligence, his expertise spans a dizzying array of emerging technologies, from AI and blockchain to extended reality and quantum computing. Besides his recognition in the field of AI, Mr. Eastham has been independently rated as a standout lawyer by Acrita Stars and Legal 500. Without further ado, please give a warm welcome to Mr. Chris Eastham as he prepares to share his invaluable insights. Mr. Eastham, the stage is yours.
Thank you very much, Devika. What a welcome. Good afternoon, ladies and gentlemen, esteemed faculty and distinguished students. I'd like to thank the National University of Advanced Legal Studies Alumni Association for inviting me to speak today. It's an honor to be here to discuss a topic that is not only at the forefront of legal discourse, but also is constantly day. And so what we're going to look at is navigating the shifting legal landscape. I'll start by saying that we stand at an inflection point and complex legal challenges, as well as operational transformation in the media and entertainment industry. From the rise of digital streaming and social media to the implications of artificial intelligence in content creation, emerging technologies are constantly causing the sector to reflect and to reinvent itself. And we must remember, technology doesn't operate in a vacuum, and that changing technology leads to changing business models. The legal profession, those of us in the room and remote, are uniquely positioned to help develop and to help advise on the frameworks that are going to be required to ensure that these advancements are harnessed responsibly and ethically, whilst ensuring that our clients are able to adapt and to innovate in a changing world. And as a technology lawyer, my role is typically to enable responsible innovation in a way which optimizes the business case for emerging technology through maximizing the benefits while making sure that the risks can be minimized. So today, we're going to take a journey together through some evolving legal issues that accompany these technological innovations. And whether you're a legal practitioner or a scholar or a media industry professional, understanding these challenges is going to be crucial for shaping the future of the media and entertainment industry. So to remind ourselves of the consequences of failing to evolve, let's start a moment by going back in time to 1985, and a man called David Cook purchased a video store franchise in Dallas, Texas, mainly because his wife, Sandy, wanted to get into the video business. And this was a time of videotapes, when VHS and Betamax were both still popular formats. His business was hugely successful, and it eventually grew to be a multi-billion-dollar company. In June 19 same time, launched its subscription fledgling ship with a where companies online the competitors to be Walmart and Best Buy, all bricks and mortar in 2010. was heavy television to have changed. It's been driven by the widespread availability of broadband internet access. And the big players in content delivery now are the streaming services, Netflix, Amazon, Disney+, Apple, Hulu, etc. And whereas pre-broadband, it would take days to download a single standard definition film, or a month for a high definition film, today, high definition content can be streamed in very close to real time with over-the-top delivery. And with OTT, in contrast to broadcast, we've got much greater flexibility in when we choose to watch. We're no longer tied to a broadcast schedule set by other people. And this has completely changed our relationship with content as a form of entertainment. In the last decade or so, as we've moved to online consumption of media, we're delivering masses of user data to those controlling the modes of distribution. Are we still online? I've lost the video from the room.
So we're facing a few technical issues. We'll be right back. Thank you.
Hi, sir. So while they're fixing the internet issue, I'll just explain how the Q&A session we're planning to do is. So we've sent out a link to the participants, and they will be sending their questions to that particular link and sharing the screen at the end of the presentation, and we can go question by question by looking at the screen and moving forward with the same.
Okay, great.
So you're still audible and visible. You can continue.
Okay, thanks.
Thank you.
So just as we were talking about high-speed broadband and live delivery of content, where was I? Yeah, so in the last decade or so, we've moved to the online consumption of media. And we're now delivering masses of user data to those that are controlling the mode of distribution. So as a consequence, they've been able to deploy algorithms allowing for personalized content delivery, enhancing that user experience by recommending content based on individual preferences. So high-speed internet and personalized content. And another development that's changing our habits is the advent of 5G, which is done for where we consume content to so it's done for where we consume to when we consume. So gone are the days when we would sit at home with our families in the early evening watching a box in the corner of the room. 5G now offers higher speeds and lower latency, allowing for smoother streaming of high definition and 4K content onto your mobile device. So it opens the door now for augmented and virtual reality applications, offering immersive experiences in live events, and it offers interactivity. And 5G also helps content producers to manage remote production more efficiently. So broadband, personalized content, and 5G. But speaking of content production, we can also consider how technology has changed what we consume. So these days, the younger generations, and I guess I'm looking at the room, younger generations are increasingly eschewing traditional film and television, and they're moving towards short format video content, often by amateurs. And this is the impact of social media. And platforms like Meta, TikTok, X, Instagram, they've become crucial for content distribution, for audience engagement, and also for citizen journalism. Now, whilst in some ways this represents a threat to traditional media creators, it also provides new opportunities for engaging with the audience and deepening the experience of the franchise. And it's also giving fledgling filmmakers the opportunity to access larger audiences without the need for big budgets. By placing themselves at the heart of the content ecosystem, big social media companies now wield an extraordinary amount of market and indeed political power. And in response to this, we've seen a whole raft of digital regulation from the EU, including the Digital Markets Act, which seeks to prevent unfair practices by dominant platforms. And that includes obligations to ensure interoperability, to enable third-party services to interface and create a more level playing field in the digital market. And we've also seen the European Digital Services Act, which is focused on the responsibilities of digital platforms to create a safer and more transparent online environment. And that restates some of the previous rules that we had around intermediary liability for online content, but it does impose greater obligations on platforms to ensure better content moderation and the removal of unlawful materials. In the UK, we've seen similar moves, and Ofcom, the telecoms regulator, tasked with enforcing the new Online Safety Act, which imposes obligations on platforms, again to remove harmful content, but also to improve protections for children and young people. And all of these new regulations, of course, have substantial penalties attached for non-compliance. But even when the material we're seeing is safe and lawful, we still need to take care regarding the potential for societal harm. And increasingly, with the use of algorithms such as content recommendation and profiling based on our personal data, platforms are feeding us material that aligns to our own particular viewpoint. And the reason they're doing that is to drive our engagement, because the more that we connect with the content, the more that it resonates with us, the more we're going to engage, and it's going to generate more revenue for them. But an unfortunate side effect is content bubbles, from which it can be very hard to break out, and the potential for individuals indeed to become more extreme in their views because they're in those echo chambers. But whilst we take care, this ability to leverage big data to understand audience behavior and to optimize content strategies can also lead to innovation in creating exciting new content and experiences for all of us to enjoy. Other technologies coming in, such as virtual and augmented reality, and they're being used to introduce new dimensions in storytelling, offering immersive experiences in various media formats. And then combined with 5G, we're now reaching a point where immersive entertainment can be with us wherever we go, even when we're on the move. Another trend that we've seen in media and entertainment is that of decentralization. In the days of VHS and even DVD, video piracy consisted of making bootleg copies of authentic tapes and DVDs, or using recording equipment in cinemas, which were then distributed by disreputable individuals. They were often of low quality, and as we moved into online distribution, we began to see much higher fidelity copies of digital files appearing. So distribution online. So what do the pirates do? They have to find a solution, and peer-to-peer file sharing was the answer. The music industry was the first to bear the brunt of online piracy because the smaller file sizes of songs makes them easier to download and to share. But of course, as broadband comes along, internet speeds increase. The film and television industry has also increasingly been affected, as has the video game industry. And whilst it may have started with hobbyist pirates and kids who thought it was a cool thing to do, it rapidly became more sophisticated with better funded file sharing operations. It's also very difficult to use legal takedown remedies because it's very easy to set up a replacement site when one is taken down, and you end up playing a high stakes copyright game of whack-a-mole. Other developments included pirate websites moving offshore, so moving to China or to Russia to escape prosecution from Western and European laws in particular. And this phenomenon, known as bulletproof hosting, became a particular trend since the successful Swedish prosecution of the Pirate Bay in 2009. The movement of pirate websites to foreign jurisdictions can't easily be tackled through litigation in those countries, and so often the rights holders have to take a more nuanced approach, including a combination of legal remedies and other approaches. Another form of decentralization we've seen is the emergence of distributed ledger technology, DLT, so blockchain. And blockchain is being explored for secure content distribution, for example, but also for NFTs, non-fungible tokens, which are offering new avenues for the monetization of digital content. And whilst we're not seeing whole feature films being funded, we have started to see smaller projects financed through token issues. And indeed, NFTs could provide a way to get more underrepresented voices into the film business, opening doors for ambitious artists. And NFTs are giving fans the opportunity to obtain digital merchandising. So it's opening up new options. There's a whole raft of legal issues when it comes to NFTs, from IP, data privacy, risks in money laundering and terrorist financing. But even putting those legal issues aside, there's a more fundamental one around ownership. What do we really own when we buy an NFT? And the reason for their popularity is the way that blockchain technology operates. It enables that audit trail to evidence the chain of ownership of each token. And for that reason, NFTs are capable of representing ownership of both digital and real world assets that might be associated with those digital tokens. But who owns an NFT? And the answer to that is less straightforward than many market participants imagine. So with NFTs, just with any intangible asset, title can be bought and sold. And when this is done via an NFT exchange, the transfer of ownership is recorded on the blockchain at the same time, providing that immutable record of the transfer. But of course, transactions transmitting legal title can also occur off-chain, and you might have private arrangements between buyers and sellers, concluded simply by agreement underhand, or even verbally. One would then expect the parties to record the transaction on the blockchain by sending the NFT from the seller's wallet to that of the buyer. And in fact, some of the most significant NFT sales, such as NFT art being sold through auction houses like Christie's, are conducted off-chain and then manually recorded afterwards. But of course, it's entirely possible to transfer title without it being recorded on the blockchain. So while buyers are well advised to ensure that the transaction is recorded for evidential purposes, there's no legal requirement for that to happen. And then a further layer of complexity emerges when you consider all the different forms of security interest that can exist over intangible personal property. So the corollary to this is, whilst it's of persuasive evidential value, the immutable record and source of truth. And in that context, how can any buyer be sure that when they buy an NFT on an exchange, they will actually receive the full title and full legal and beneficial title, free of all encumbrances? Now, by my clock, we've been going for about 20 minutes, and I've managed to talk about emerging technology in media and entertainment without mentioning artificial intelligence. There it is. But in reality, AI largest potential for disruption. The Writers Guild industry of any technology I've mentioned represents about 11,500 screenwriters who programs and other content, and it's responsible for a collective bargaining agreement with the Alliance of Motion Picture and Television Producers, which is a collection of the studios, called the Minimum Basic Agreement, or MBA. And essentially, if a student, for a show, it needs to sign up to the MBA. Now, in April last year, the A and the AMPTP couldn't reach an agreement that was satisfactory. And so from 2nd of May through to the 27th of September, the Guild went on strike. And you've probably seen this in the press. With a duration of 148 days, that strike was the second longest labour stoppage that the WGA performed in its history, and was part of a series of broader Hollywood labour disputes, alongside the strike by the Screen Actors Guild, which continued until November. And those strikes contributed to the biggest interruption to the American film and television industries since COVID-19. Now, the lack of ongoing film and television production resulted in some studios having to close doors or reduce staff, and it jeopardized long-term contracts that were set up during the media streaming boom through the ability of studios to terminate production deals under force majeure clauses. So the effects were widespread. It affected the VFX and post-production industry and prop-making studios. The whole industry sort of came to a standstill. And all told, it caused about an estimated $6.5 billion loss to the economy of Southern California alone. And AI was one of the key points of contention. So to understand why, we first need to understand the IP situation when it comes to generative AI. And I'll preface this section with a disclaimer that I'm an English law qualified lawyer and that treatments do differ around the world. And in fact, that's part of the problem. Who owns the copyright is an important question. And obviously it has substantial economic impact and dictates subsequent transaction structures, where you've got multiple people working together to create content, or when one person engages another to create content. Under English law, it's a matter of contract as to who owns the copyright in the output. And in the absence of a valid contractual assignment or an employment relationship, then the ownership remains with the person that the law provides is the first owner, which is the person who creates the work. And similarly in the EU, the author who creates the work will be the first owner of copyright. In the UK, we have the Copyright Designs and Patents Act, and there's a provision in there that was introduced, it's well over a decade now, and it anticipates computer-generated works as being capable of copyright protection. And the first owner of that copyright is the person who made the arrangements necessary for the creation of the work. Now, in the EU, the same position doesn't exist, and there needs to be a greater degree of human intellectual creation for copyright to subsist in a work generated by a machine. That interpretation wouldn't prevent copyright from subsisting where an AI has been used to assist in the creation, so long as there's been sufficient human input to have satisfied that intellectual creation test. The US Copyright Office has taken a different view. And what they have said is that purely AI-generated content, not having a human author, using a degree of creativity, doesn't enjoy copyright protection, and therefore there is no author for copyright purposes. And this has been evidenced by various cases, but an obvious one is Stephen Thaler's AI-generated painting called A Recent Entrance to Paradise, and that was denied copyright protection in the US due to the lack of human authorship. There is some comfort for AI-enabled creators. There was a case in 2022 in the US involving Chris Castanova's comic book called Zarya of the Dawn. The US Copyright Office decided that the AI-generated images in the book were not eligible for copyright. They weren't protectable. But the case did highlight that the copyright could subsist in the arrangement of the works. Indeed, the author obtained copyright protection for the order in which the AI-generated images appeared in the book, but in the comic book, but not the images themselves. So I think you recognize the challenge here. If we have screenwriters starting to use generative AI to develop their work, then is that work protectable by copyright? Well, probably not. And therefore, could that undermine the studio's ability to monetize the end product? So for that reason, studios were very concerned about writers using AI. Generative AI could be used by studios in producing early drafts of screenplays. So that would make the writer's job much more of an editorial role and reduce employment opportunities. And frankly, that's not the job they wanted to be doing. And another concern was that AI could be trained on a writer's work and in future may displace them really from the job market. So the terms of the latest MBA that was agreed and the way that they resolved this to end the strikes was firstly by excluding AI-generated works from the scope of literary materials that give rise to writing credits and compensation. So is deemed to have value under that contract. And secondly, it contractually prevented the studios from using AI to rewrite scripts from requiring writers to use AI or from using writers' materials to train AI. So any use of that nature would have to be negotiated later with on a case-by-case basis. The Screen Actors Guild had they were concerned that AI technology might be used to reduce the need for actors in films, and that they weren't adequately protected by the existing consent in the SAG contract. The new strikes provided a greater degree of control for screen actors over the use of their likeness digitally created, and then a fairer remuneration where a replica was used. Budget films, if you have big battle scenes, and you wouldn't have thousands of extras running down a valley, you would use AI, but you need to work out, okay, how do we remunerate for that? And that's how they resolved the issue. So it's provided a solution for now, at least sufficient for the strike to be resolved. But the MBA will be up for renegotiation in 3 years. And of course, in 3 years' time, we may be looking at far more sophisticated AI technology. So that threat of job displacement is not gone. Now, at the start of this talk, I told you how my role as a tech lawyer is to enable responsible innovation in a way which optimizes the business case for AI through maximizing benefits while making sure we minimize risks. The way that top organizations are doing this in relation to AI is by implementing effective and considered governance frameworks. Now, I say effective and considered because they need to be effective to understand and manage risks, but they need to be considered because we don't want to over-engineer them so as to build barriers to innovation. And actually, we've seen some organizations getting this wrong, and it will reduce the ability to compete in a rapidly changing situation. The biggest change in the legal landscape for AI, of course, is the introduction of the EU AI Act. That was approved on March 13th by the EU Parliament and on May 21st by the Council, and then it was published in the official journal on the 12th of, so that's when it hit the statute book. It came into force on the 1st of August this year, so relatively new. It implements a tiered system of regulatory obligations for a list of AI use cases. At one end, we've got certain systems referred to as prohibited AI systems, and they're going to be banned completely. We've got applications such as deepfakes, chatbots, and biometric analysis, which must clearly disclose themselves to affected persons, so there's sort of transparency obligations. But then the broadest of the designations are the high-risk AI systems, and they have to meet standards of data quality, accuracy, robustness, and non-discrimination, whilst also implementing technical documentation, record keeping, risk management, and human oversight. So that sounds like governance to me. Entities that sell systems are called providers, and they need to meet those requirements and submit documentation that attests to the conformity of their AI system. Now, it comes in not all at once, but in a phased manner. So on the 2nd of February, in about 4 months' time, the chapter related to prohibited practices comes into effect. And in the entertainment sector, the most relevant prohibitions are likely to be those relating to those AI systems using subliminal techniques or purposefully manipulative or deceptive techniques, which then cause someone to take a decision they wouldn't. AI systems that exploit vulnerabilities due to age, disability, or a specific social or economic situation. And you might persuade young people to make in-game purchases. And anyone found to breach these provisions may be liable for very substantial fines, up to the greater of 35 million euros or 7% of global turnover. It relates to, and this is an obligation to ensure relation to AI. Now that has a sufficient exercise because organizations have to ensure the sufficient level to their best extent. And so organizations need to attend to this now. They've only got 4 months now to comply. The rules for general purpose AI come in August next year, and then a further 12 months later, we've got all the remaining provisions including those relating to Annex 3 high-risk systems. So those are the ones related to particular sectors. And then 12 months later, we've got Annex 1 comes in, which are the ones that relate to the European harmonized legislation. So there is a little bit of a distinction between different types of high-risk systems and when the obligations come in. We've also got the various transparency obligations that I mentioned. So any AI system that's intended to interact with natural persons. So the principal obligation there is on providers to ensure that they're designed and developed in a way that the natural persons are informed that they're interacting with an AI system. In relation to generative AI, the provider needs to ensure that the outputs are marked in a machine-readable format and detectable as artificially generated or manipulated. So you can see how that could be helpful in the writer's context. You've then got deployers being responsible for emotion recognition systems and biometric categorization systems, and any system that generates or manipulates image, audio, or video content constituting a deep fake. So again, you can do it as long as you're transparent about it. In the UK, we're taking a more agile approach, and the government's published a number of strategy papers, but broadly speaking, the approach is as it has been since the House of Lords paper back in 2016, which is that responsibility is being devolved to the sectoral regulators, even with the change of government. Although there's noise about regulation, nothing specific has really been proposed yet. It's nothing hugely impactful anyway. And of course, we need to consider other regulatory issues arising out of legislation such as GDPR and the Equality Act. Now, I was going to talk a little bit about governance, but I'm conscious that we started a bit late and we might want to catch up. So what I might do is just give you a quick example of where AI has been important in a recent deal that I advised on. So obviously the legal issues are very wide, from protecting confidential information through IP, through data privacy, through integration with existing systems. We need to concern ourselves with the potential for hallucination, the potential for bias, but also we need to think about what contractual arrangements are in place. It's not we need to think about the controls on outputs in particular. And some of those controls get flowed through the value chain. We've seen some AI vendors, so Microsoft, for example, Google, they give a commitment around IP infringement in relation to output content. But they also, in some cases, have terms which have the potential to lock customers in to only using their technology in the long term. And of course, that undermines the potential for those customers to innovate. So I was advising a client, I can't say who, on a $1 billion software deal with Microsoft earlier this year. It was sort of between January and March, closed around Easter. For the first time, we came up against was the controls around outputs of AI. And the wording that appeared in Microsoft's standard product terms was so prohibitive that it would have had the effect of imposing a Microsoft monopoly within the client's IT ecosystem, and also locking the client in to being run on Microsoft platforms and preventing Microsoft from being disintermediated. Now, there's a common misconception that you can't negotiate with the Microsofts and Googles of this world when it comes to their terms of business. But with the right team in place, you absolutely can achieve traction. And we knew this, so we dug in. And through 3 months of hard work and determined negotiation, we managed to get the contract wording to where it needed to be to allow the deal to proceed. And then I was delighted to see a few weeks later that Microsoft had updated its standard terms of business to reflect the change. So I can very much say that we genuinely shaped the AI market with that deal. So in conclusion then, as we navigate this ever-evolving landscape of media and entertainment, it's clear that emerging technologies are both a challenge and an opportunity, from the transformative power of AI and blockchain to the pervasive influence of social media and streaming services, these innovations reshape how we create, distribute, and consume content. And as legal professionals, we have that unique responsibility to ensure that these advancements are harnessed ethically and responsibly. We need to develop those robust legal frameworks that protect IP and the economic rights of creators, that ensure fair competition and a dynamic marketplace, and that safeguard individuals' privacy and human rights, all while fostering innovation and creativity. And the story of Blockbuster's collapse serves as a poignant reminder of the importance of adaptability. In a world where technology is constantly advancing, staying ahead of the curve is not just an advantage, but it's a necessity. And by embracing change and leveraging those new technologies, we can create a vibrant, dynamic media landscape that benefits creators, benefits consumers, and benefits society as a whole. Thank you for your attention, and I look forward to the exciting future we will shape together.
Thank you, Mr. Eastham, for your enlightening address on the evolving role of technology law and its broader impact on emerging technologies. Your insights have provided much food for thought. We now open the floor to any questions the audience may have. The questions will be broadcasted on the screen. So I hope the screen is visible to you.
I don't see a screen at the moment, but if you want to read out a question, I'm quite happy to consider it.
All right, so I'll be reading it out. First question is it possible to include technological obsolescence under force majeure clauses?
So you broke up a little bit there, but I think the question was, is it possible to include technological advancement in a force majeure clause?
Yes.
Yeah. Well, in theory, I guess you could, but I think the likelihood of the other side accepting it are probably relatively limited. I think because generally speaking, force majeure is used to deal with things which are not foreseen by the parties, and I think that generally speaking, technological advancement is foreseen. Technological obsolescence under force majeure clauses. So the way I'll address both questions. So technological advancement, in fact, probably advancement and obsolescence are both best addressed through governance clauses under the contract. So, for example, software vendors will have provisions in their contract to say that actually they will update their technology. Existing products, they will take them off the market and replace them with other things, and that tends to be considered in contracts. I mean, there is a risk, I think, when customers are signing up to contracts that they may buy something that then, becomes obsolete. So I think in the rapid world of a risk. We talk about large language models now, but small language models are in development, and I'm sure the next latest greatest thing is in a lab somewhere, and we just don't know about it yet. So there is the risk that if you double down and you invest heavily in a technology now, it may be obsolete in the very near future. But that is a risk that you have to take and manage through the other contractual levers. I think it's probably unlikely you would get it in a force majeure clause.
Thank you, sir. On to the next question.
Yeah, this is a difficult one, and it will vary based on jurisdiction. But generally speaking, it will go to the natural person who is generating it. So certainly in the UK, the law says that the author will be the person who makes the arrangements for creating the work. Now, providing an AI system wouldn't go far enough towards making the arrangements. and it needs to be the specific arrangements, not the general arrangements. So, where does the creativity really come from? It comes from the person who is putting the prompts in and causing the AI to generate that work. So that's where to the extent that copyright subsists, that's where it would go. And I think, in other jurisdictions, so in the EU, it comes down to that intellectual creativity. So it absolutely has to sit with a natural person.
Thank you, sir. I think it's a much conflicted.
Yeah.
Next. Shouldn't parents take responsibility instead of blaming technology?
Well, that's a philosophical question, isn't it, rather than a legal one? But as a parent, I know how difficult it is to control and to monitor and supervise what your kids are doing. And mine are only 5 and 2, never mind, 16. I think, media platforms are the gatekeepers to this content. And therefore, the approach that's being taken by the regulators is to say, well, look, you're the gatekeepers. You are making a lot of money out of this activity, and therefore you need to have responsibility for the potential harms that it might cause. So, long time directive, we've had rules in Europe and the UK around intermediary liability, saying that if all you're doing is hosting content and you don't have any editorial control, then actually you don't have liability for it. And that has carried through into the current legislation, the Digital Services Act. But what we have done more recently is to introduce additional obligations and say, look, you're the gatekeepers, you need to take steps, even if it's, we don't expect you to have people poring over all this stuff because the volume is too much. But if you can put technological measures in place to protect people, and then when it comes to sites that are likely to have sensitive content, shall we say, on them, or potentially harmful content, particularly for children, what measures do you have in place to ensure that those who are accessing the content are of an appropriate age? But of course, there's only so much that the platforms can do.
Thank you, sir. Next question. How grave of a penalty can be awarded to someone in non-compliance with the moderation policies? Should that be too? Is this a good method of implementing liability?
Yeah, so the penalties can be very severe. So if you fail to comply with your obligations in terms of moderation, you can lose the benefit of the hosting defense. Now, the hosting defense says if all you're doing is hosting it and you've got no editorial control, then you're not liable at all in respect of that content. But of course, if you lose that defense, then you can be liable for whatever that might be brought in relation to that content. So, for example, if it's intellectual property infringement, if it's copied content, you can be liable for copyright infringement as against the rights holders. If it is child pornography, you could be liable for criminal penalties in relation to hosting child pornography. So yeah, there absolutely can be very severe penalties there.
Thank you, sir. On to the next question. What is the significance of a smart contract?
Okay, so smart contracts are neither smart nor contracts. That's probably the first thing to say there. The smart contract is simply the part of the NFT that codes sort of what happens, right? It's just that section it's what they call the section of the NFT that gives the information about what the NFT represents and what the remuneration split might be if there are royalties, etc. It deals with those things. It can be somewhat automated, but it's not, at least as far as I'm aware, we haven't had artificial intelligence in there. But it doesn't form a conditions of a contract, but it doesn't in and of itself form a contract. You still have to have offer acceptance, etc.
Thank you, sir. Next question is, will the use in AI or of other elements which reduces the significance, will this lead to monopolistic nature in the market and abuse of dominant position?
Possibly, and I think this is one of the concerns. So I talked about the writers' strikes in particular. I think if you think about, if all the studios started using AI, then of course you might lose the benefit of all those writers. You have a load of people out of work, and the studios can gain in power because they've got access to the technology, because they've got the investment. They can create better content, and it makes it much more difficult for smaller businesses, smaller filmmakers who don't have access to the same investment, same technology to compete. Although, of course, you could see it the other way, and you could say, well, if we democratize AI to everyone, actually, doesn't it open up the market for new filmmakers who have access to this technology that is the same technology as the big studios are using? And this is not just media entertainment, but any industry which relates to the creation of content or even other areas. There's a question around access to technology and technology as a force multiplier, if you like, in how effective you can be in business. And if we democratize these tools, if we make them available to everyone, then we can open up the market, we can make the markets more dynamic, we can level the playing field. If the tools are concentrated in the hands of the hyperscalers, so Microsoft, Google, Meta, etc., or in the hands of big corporates, then yes, we may see a concentration of power and potential abuse of dominant position. So I think it's really important that we are careful about the way in which AI is promulgated and try and avoid it being concentrated in the hands of the few.
Thank you, sir. Okay, so was Taylor Swift case with master recordings, could it have been resolved if the blockchains were used as medium to her conservation of rights?
I don't know the answer to that one. I think I'm not close enough to that case to be able to comment on the intricacies of it.
Okay, sir. Thank you. So, sir, what is the status of pirated content's adaptability? Disregarding ethical connotations, would the increase in piracy become a consequence of the increase in streaming content or a hindrance to it?
I'm not sure. I'm just reading the question again. Let me try and understand this. What is the status? Are we talking about whether the increase in piracy would increase? I'm not sure I understand the question. I think that with streaming content, streaming is one way that the content distributors can, reduce the impact of piracy, right? Because if you are selling, let's say, films, right? You're selling films on a film by film basis, and there is a charge for each one. Then, of course, if there is a free version available, those who are less concerned with ethics and legal implications may well decide to obtain the free version rather than the paid version. Whereas if you are offering a subscription service, which gives your customers access to a wide range of media, and you're not paying on a consumption basis, you're just paying for access to the library, actually there is a reduced incentive for people to go and pirate material because it's all there available to them. So I think what you're doing there is you're changing the nature of the product you're changing the nature of the product from content to access to content. And so I think streaming is a way of reducing the impact of piracy. I don't know if that quite answers the question, but hopefully it's insightful.
Thank you, sir, once again. So that brings us to the end of the question and answer session. Thank you once again, sir, for your thought-provoking questions and engagement throughout the session. It's been an absolute pleasure to receive insights on the evolving landscape of technology law and its intersection with emerging technologies. I hope the discussion has sparked new ideas and perspectives for everyone to explore further. Thank you.
My pleasure. Enjoy the rest of the conclave.
Thank you.
Hello. Hi everyone, so we'll break for lunch. I would request you to assemble back here. The next session will take place here. It is a panel discussion. It is mentioned in your schedule. So we will assemble back here at 2 o'clock. It will start sharp at 2 o'clock. The lunch is arranged in the academic block. You can refer to your map that is given to you in your files. Academic block, ground floor, lunch is arranged. So you may proceed that way. Thank you.